Hi everyone, this is Joseph. Thank you for tuning into today's channel. Today's main story that we're going to talk about is non-immigrant visas, specifically dealing with the Koreans, that 300 plus Koreans that have now been sent back to Korea, supposedly, allegedly in violation of their immigration status. There's a lot of confusion surrounding this news topic, but instead of just kind of explaining what the immigration laws are, who's right, who's wrong, and kind of doing a deep dive into the news facts, I think it might be more informative and interesting to talk specifically to those who are anti-immigrants. And the reason I say that is because this past week we did a consultation for a company, like how we do all consultations. This is a company, this is the HR department, and they wanted to know how to build out their company better using immigration. And I feel like a lot of people in this country, and not just the United States, actually worldwide, but I'm focusing on specifically U.S. immigration. A lot of people are anti-immigrants in part because they haven't received any benefits and they feel like their rights and their benefits have been infringed upon. I'm not talking logic right now. I'm just talking emotions. And again, I'm doing these live shows. If you guys have any questions, feel free to ask. But I feel like I want to start talking about this Korean company, Hyundai, sending US workers to the United States on various different visas, and now in supposedly violation of immigration laws, they have now been sent back. Did they violate U.S. immigration laws? Did they not? Well, more specifically, if you are a U.S. company owner, if you own a corporation, an LLC, a sole proprietorship, and you feel like, oh my goodness, all these other blue states, coastal cities, all these other people are having cheap labor, free labor come into the country and compete against us. It's not fair. We need stronger crackdown. We need to crack down on illegal immigrants. This is for you. This is what I want to talk about because, again, just like how I do these consultations for corporations, thinking through how to use immigration to help their company, I feel like a lot of people just don't quite understand how immigration can benefit them as well. And if they did understand, and if they had more connections with immigrants, and I don't mean in like a demeaning sense where you go to a restaurant and like the cook or the dishwasher back there is an immigrant and you're benefiting from the cheap food. That's not what I'm talking about. I'm talking about personal, close connection, right? When you are married to immigrants, when you are when you have immigrants in your family, when you have employees who are immigrants, and when you have overseas companies and you need to transfer executives over, you might have a different perspective on the immigration policy. Not guarantee all, but at least you're maybe more sympathetic and more understanding of other people. And I think that's what we need in this country right now to kind of bridge that understanding. So let's talk a little bit about what happened. And if you are a company, how can you also can benefit from the immigration system? Because you don't want to discount the immigration system as completely broken. It's actually quite sophisticated and arguably the best in the world. And I want to explain. So I think by now a lot of people understand that there were plenty of people who got the B1 visa to enter the United States. And if you don't know what that is, it is a business visa to come to the United States. Their salary is paid by the employer abroad, and they have to do critical work here in the United States in order to benefit a U.S. entity. Now, what does that mean for you? And what in this case, right, it was supposed to be a battery plant that they need to help set up because there's so much technology and infrastructure that needs to be created, and U.S. workers don't have the know-how, specialty knowledge in order to set everything up. So that's why they had to send people from overseas. The classic example of this are engineers who work on the software, who worked on the machinery. They are the only ones who know how to do it. But if the US wants that technology, they want to be able to implement, they need those engineers to get a visa to come over here for a short period, 1 month, 2 months, 6 months, set everything up, do the training, and then leave. And then now US workers receive the training and now they know how to operate, right? That's the classic case of a B1 application, and that is legal and that is lawful, and that makes perfect sense, and the US has been doing that for years. So I think most people know that right now. So in the situation in Hyundai, they're trying to build out this factory, this battery plant, and they just can't find enough US workers. You could say there's no way they could totally hire a couple cities away and for a whole team. It's just a matter of cost that they want to send all these people over. It's actually a little bit more complicated than that, right? Because the language requirements that they have to build and the technology that they have, it's not so easy that they could just immediately hire somebody else. It's not just like, a small interior design of a company. Sometimes they need to hire, again, in this case, it was 300 plus people, right? It's not a small amount. And so really what we need to take a look at to really decide if they violated any rules is, out of the 300 people, how many of them got the B1 visa, right? And what they say during the B1 visa interview, how many people did they hire on top of the 300 people? So, I mean, we're clueless about that, right? If they had 300 people and they hired another 1,000 or another 300 or 500 other US workers to work side by side with them, that sounds like the ratio is about right? But if the company was just trying to save money and they didn't hire anybody else and were just purely relying on a portion of B1 visas, a portion of L1A visas, a portion of L1B visas, and a portion of a visa overstays, then it might become like, oh, there's a conspiracy here to kind of evade immigration law, and some of the people, they were just trying to save cost. That might be true. It depends, right? And again, there's so much confusion about what people can do on different visa categories, right? If you're on a visa waiver, if you're on a B1, B2 tourist visa, you're not supposed to work. Not even going to the plant and, doing consulting. That's considered work. You're supposed to get a B1 visa for that. Now, B1, B2 tourist visa allows you to be an investor, right? And so they could technically come and check out things and say, yes, I want to invest more. So that's not against immigration law. But if you're on a visa waiver, and you're a tourist, but you're coming in, you're paving things, and you're doing electrical work, well, you should have hired a U.S. worker for some of those jobs. Again, things could have been complicated. They might have been on a tight time crunch. They were trying to save costs. They took the risk, and they got busted, right? The consulants were too savvy. They see all these B1 cases go through. They see what they were trying to do. They know the location. They send one fraud inspector take a look at it, and they just see hundreds of the Koreans going into the plant. They say, well, they didn't get that many visas, and they were on a tight crunch. Then they did an I-9 bust. The craziest thing about this is the penalty that this carries. The reason why the Korean government and the US government had to get involved with this, because even though it seemed like such a small little thing, a visa overstay using, a few hundred, maybe, right, allegedly, illegal visa holders to do work, circumspecting US immigration laws and labor force, is because of the I-9 penalties. And what I mean by that is, if a US company knowingly violated immigration laws by hiring somebody without the proper documentation, and they failed the I-9 report intentionally, it carries fines, but it also carries jail times. And so I think that is something that maybe the public doesn't fully appreciate and know, is that there's so many different visa categories, whether you're on the left or the right of the political spectrum, whether you're a coastal city or you're not. There's so much immigration law that can benefit your company. But if you don't do it correctly, it carries with it severe fines and jail time. And if you just look up I-9 violations history, companies have had to close down and go bankrupt because of I-9 violation, because they count every single paperwork violation. Oh, you didn't submit this paperwork and you failed it the second time. It compounds. And if you have a lot of employees over the number of years, it compounds quite quickly. And suddenly, instead of IRS sending you owe $1 million, now it's ICE sending you, hey, because of the I-9 violations, now you owe back this fine of a couple $1 million. And that is sufficient to bankrupt almost all small businesses, right? Just doesn't make sense to process it anymore. But what's more severe is the jail time. So again, this is something that we haven't seen on a wide scale. I have been predicting for a long time now that ICE is going to do I-9 enforcements severely, especially after they staff up and after they run out of quote unquote political targets that they have been empowered to do right now. But once the staffing level is up, they could go through, and that's within their rules and regulations, right? And they're finding businesses for violating immigration law, and the public is much easier to stomach those challenges as opposed to pulling people away and deporting them, right? I feel like this is very much going to be the future, but because this is such a huge company that is integrated to all of Korea's GDP as well as the US GDP, and it's such a huge bust and it carries jail time, it was a very sensitive issue that they had to clarify. But there's just so much confusion around the immigration policies between the B1 visa and what visa waivers can do, and did they violate any status. Chances are it's a combination of a lot of things. The people who had the proper B1 visa, they shouldn't have been terminated because they were doing exactly what they were supposed to be doing. But maybe in their interview, they said they were going to be leading 20 other U.S. workers and training them. But in reality, I don't know. I don't know how many U.S. workers were there, right? Visa waivers, maybe they were supposed to just go visit, but then now they're actually working. So maybe they're in violation. The L1 people, well, they were supposed to be an executive, but somehow they were doing electric work. Maybe there was problems there. So again, there's different visa categories, and it's not just a straight, clean-cut case where there's some sort of violation. But the truth of the matter right now is the visa process. It's complicated. It's long. I know there are companies who try to not go through the proper channels of applying for the right visa categories, and they just use their tourist visa, their visa waiver, right? A lot of countries who are good partners with the US, such as Korea, Canada, the UK, they have visa waivers, and so they easily come in. And when they easily come in 3 months, 6 months, all their friends and family easily come in 3 months, 6 months, then it's just one step away from setting up a business and then having their friends and family come over to the US and work, and we're not having to pay insurance and all sorts of stuff. But once this gets more severe and there's a widespread I-9 audits, then fines, then jail time, notices go out, and I think that will send a clear message to the rest of the world. But again, the fault is not on the visa process, right? It is a little bit complicated. It's a little bit long. There's a lot of paperwork involved, but that's the proper channel. And the US has one of the most sophisticated immigration systems with all the proper visas. So if they just applied for it and stuck with the plan, it would have worked. But, right, something somewhere went wrong, but it is not all bad, right? I'm sure there were some that were correct. And so that's why this is a very sensitive situation. But I think I just want to take this opportunity to share this kind of information. So people who are on the right, who have never benefited from immigration, I just want you guys to know that immigration is a great policy that the US government has set up to try to make you successful. Once you know, now you know, hopefully you can take advantage of it as well.
With a small company, a landscaping company, how can you apply for a visa?
Let's directly tie this in, right? Let's say you have a small landscaping company in the US and you want foreign workers to come in to help your company. What can we do and how can we set it up, right? So let's talk about the B1 visa, just like what Hyundai did. They were able to come to the United States because there's some critical technology that they need to implement. Let's talk about digging, right? Digging. You could dig with a shovel, but that will take a long time and manpower is expensive. You could have a machine that digs, But right now on the market, if you're trying to find some digging equipment, probably cannot find it because all the big companies have already used it, or it's not for your small backyard scale. But you're a landscape company, and a lot of times you need that digging device. What if you contracted with an employer overseas that created these customizable, smaller digging machines that could fit in a van? Now they can send their engineers to come over, show you how to use this machine, and you can now dig, and you go on a 10-year, 20-year lease agreement with them, and then your employees can learn how to do it. Now you can help them get a B1 visa to come over to do that, right? So that's a B1 visa. Now, if you're talking about like E2 visa, there's so many other visa categories, totally possible. We did a YouTube story where a Harvard graduate that's a UX designer, right? And then they got their visa through the H-1B for a landscaping company. Crazy case, but that story's on there, right? So again, landscape company, you could do E2, you could do B1, you could do TN is a little bit harder these days, but not impossible, right? But like I said, if you have a company in the United States, there are so many different visa categories where people and companies and families who are so willing to come and help your company succeed just because you're able to give them a visa, right? We're talking about investors. People will gladly invest in your company, give you hundreds of thousands of dollars without any interest, maybe with 1% interest. But think about that compared to small business loan, right? They're willing to give that amount because once they become an owner, some cases just 10%, some cases should be over 50%, 60%. But if they can be owner of your small business, then they have the possibility of getting the visa, the whole family is able to come over. They gladly invest. Again, other people and all around the world, they have their own visa categories where you invest and you get visa. In the United States, we have plenty of different options, but the E2 and the EB5 is an option. Then there's the B1 visas where they just executives come or just employees come over, engineers comes over. And then if people need to stay here for a little bit longer than 6 months to a year, then there's the L1B, there's the L1A that you can bring other executives over. Crazy, smart, talented, capable executives that can make your dream come true, leading your company. You can bring them over on those other visa categories as well. So again, during the consultation with the client, talking about how to use the immigration system and make their company better, right? All the legal different ways to do it. So we went from students with their CPT and OPT training programs. So looking at all the universities around their company, the different internships available, partnering with different trade schools, right? So there's that option, right? For students and for international students. And then paving the way for the H-1B, the self-petition route as well. And then there's the O1 extraordinary ability. And then there's the B1, L1A, EB2, EB3 to get a green card. There's all the different ways that you could build out this pipeline. So really talented, capable people that are normally impossible to get, but if they're able to join your company, then they can make your company flourish. And I think that's what a lot of people kind of just don't understand. And again, this is the law. This is immigration law created by Congress to help American businesses thrive. Prioritizing U.S. workers for sure, but in the event of you cannot find enough contractors to help build up your electric power plant, that you have to send people from overseas to come over for 6 months to a year to build everything out. And then, and only then, do they leave, and then U.S. workers can come in. All right, I'll take some more questions.
My husband has been an LPR for 25 years. Now he has a DWI misdemeanor. Can he renew his I-90?
Yes, until the DUI law officially becomes where if you have a DUI, you are deportable. We have seen people with DUIs successfully renew their green cards with the I-90, successfully even get their citizenship. So if it's one DUI, I wouldn't be too concerned about it. If it's 2 or 3, maybe you want to do a little bit of preparation, but just know you are a lawful permanent resident until an immigration judge officially deems it that you are not.
My visa bulletin is current. Is this a sign that we will get an approval soon?
Visa bulletin current means you are eligible to file, but the onus is on you. You have to file for the case in order for the case to get approved. If you never file, you actually never will get the green card.
They've already filed.
Oh, well then, great. Just wait and then go to the interview if you have one.
I was removed as a child from the U.S. as a green card holder unwillingly. What can I do to re-enter now? That was 15 years ago.
You might have to apply for a new green card or a tourist visa to re-enter the United States.
I got my green card because I was married to an asylum seeker, AS7. Can I get a citizenship even if we get divorced?
Once you get a green card, the green card is yours. So unless your green card gets terminated because they suspected fraud or whatnot, the green card is yours to keep. So once you have the green card for over 5 years, even if you're divorced, you can still apply for citizenship.
Can someone get legalized through her kids, like get a green card through her kids, if she crossed back into the U.S. EWI after being deported?
Most likely not.
Can you self-petition with a small business? What do you have to do?
Great question. There's a lot of different self-petition, non-immigrant and immigrant categories. Non-immigrant meaning you get a visa, you can stay here, you can work here, you get a social security number, but you don't get a green card. You're not going to be here permanently. You can also self-petition and get a green card, and it's a more permanent way to stay and live in the United States. And then you can eventually become a citizen once you have a green card, right? So there's so many different categories, right? EP1A, EP2NIW are famous for the self-petition route, right? So that's the green card route. Non-immigrant, they just opened up some additional doors, right? So now H1B, you can do self-sponsor, and you can also do E2, and in a lot of cases, O1 as well. So again, you have a lot of different options. Non-immigrant is usually faster. You can stay and work here, and then later on, if you want a green card, or simultaneously, you can do the green card route. They are not mutually exclusive. You could do both at the same time. Generally, people stick within the same category. Like, for example, if you do an O1 self-petition to get a non-immigrant visa to stay, you usually do the EP2 NIW or EP1A. If you're doing an L1, you usually upgrade to a EP1C to get a green card, right? But again, they're completely separate things. You could totally do an O1 and then do an EP1C, for example. I know that's just a bunch of jargon, but just self-petition, there's so many paths.
Is a CEPIS reinstatement possible after 1 year gap due to a medical reason, mental illness?
Prior to having a success story, like I think last year on almost the same fact pattern, my answer would be very slim. My answer now is still very slim, but now I just have this one extra additional success story that said, oh, that was possible. And the mental illness was like, they were like depressed and stuff. But maybe this administration is a little bit different. But if you're just hypothetically asking, is it possible philosophically? The answer is yes, because we have seen it happen multiple times in the past. If you go on our YouTube channel, you look under Reinstatement, I don't know, at least 20, success stories or 30 that you can, see every single case.
I'm a single parent applying for an O1. Will I need legal documents to bring my child without the other parent?
It depends on the consulate. If you're still married, you automatically have that authority. If you're divorced, the consulate might have questions. And even if the consulates approve it, unknowingly, you came to the U.S., that doesn't mean that other country won't necessarily file an abduction charge. You see what I'm saying, right? So just because the consulate and CBP lets you in with a visa for your kid, well, you still could have abducted your own child, right?
My EAD got lost during transit. USPS gave me a letter, said your package is lost. USCIS says, well, the system says it was delivered, therefore I can't reissue it. So what should I do? It's been 5 months now.
Yeah.
What can I do?
Reapply. It's annoying. It's a headache. Just reapply for it. So you're basically a loss, and you're searching for a replacement work permit.
What do I need to do? Okay, so I applied for a marriage visa already at the NBC consulate, but I just found out I need to file separately for my daughter. What do I need to do to add her to my I-130 so they can process at the same time?
I just want to apologize that I actually don't know the answer. That's too minute of a detail on a family-based immigration case. I usually only do business immigration cases that are like more complex. That's like a paralegal question. So why don't you message us, right? And I'm happy to set up a consultation between you and the paralegal, and they can walk you through everything that you can do to fix it.
My son has been abroad for 4 years as an LPR. Now he's been accepted to a boarding school. Is CBP entry safe?
You walk me through the question again?
Their son has been abroad, LPR son, abroad for 4 years.
Oh, okay.
Now he wants to re-enter to go to boarding school.
Right. Yeah, we've done plenty of those cases, over 7 years, over 8 years. You want to prepare your documents well. When did you leave the U.S.? Where did you go to school? Why did you leave? Why the better opportunity? Where are the parents? Are the parents green card holders or citizens? Is there a home for the kid after in the U.S.? Not just the boarding school, rest of the family, tax returns. You want that whole story. Sometimes it could be 500 pages, right? Sometimes it could be 300 pages, but you want to show that the kid is fluent, and you want to show that the kid is, smart, capable, bright future for the United States. The parents have invested a lot in the child, and this was actually the best career choice, etc., and make sure the parents didn't violate any status. Now, if the parents abandon the green card and pull the kid away, and all facts indicate that the parents essentially forfeited the green card on behalf of the kid, then you have a much difficult case, but you can still prepare and try to fight it out in immigration court. But, I mean, ideally, the parents are U.S. citizens, right, who have just left. But if their parents are not U.S. citizens, or if they have abandoned the green card, it's a little bit more difficult case. But again, we've done plenty of these cases.
Okay, we're going to take a few more questions and jump back to talking about the benefits of work immigration. So on the landscaping company, they make around $100,000 in revenue. They don't have a legal entry. Can they still self-petition?
Okay, I got it. So the owner of this landscaping company did not have legal entry. So basically undocumented in the United States. Since that is the case, they cannot do any sort of change of status to a non-immigrant status, or they cannot change and adjust status to get a green card because they are here unlawfully, unless one of the exceptions apply. For example, you can look up the 245I, then they could potentially adjust to get a green card. If they're, through a family-based immigration case, be able to get a green card, but not through business, right? All questions about self-petition, that's all within the business world, right? So one of the only ways that I could foresee potentially the situation in which the self-petition will work is if they came really early on when they're a kid, and then they received DACA, they'd have no unlawful presence, they establish the company is doing well, they do a self-petition, it gets approved, then potentially the client can make the call. I'll leave the country, I'll go to the consulate, I'll get the visa, and I'll come back in, right? So, but again, that's a very narrow exception, right? You enter without inspection, so you have technically a lawful presence, but you receive DACA, so it tolls that lawful presence, and then you build up a great company, good for you, you do a self-petition, and USCIS approves it, right? All those conditions met, then you can pull the trigger. Okay, yes, everything seems like a green light. I will now go to the consulate, get a new visa, and come back in. But if, not everything is aligned, then the business won't necessarily directly help you. Doesn't mean it will necessarily harm you, right? Let's say you did get married to a U.S. citizen and then you need to apply for a waiver. The business and a successful business is definitely a good argument point in these waiver cases, showing that you are even a better American than average Americans, right? You are an entrepreneur, you employ people, you pay all your taxes, so all is not lost, but you just have to kind of make the right moves.
Okay, we're going to take 2 more follow-ups. I feel like this is when chess, grandmasters are playing on 4 different boards at once. So on the O1 going to the U.S., single parent, father's unknown or in an unknown location, and already divorced and in London consulate. So now maybe this involves British law that we can't answer, but
yeah,
do they need on USCIS's side to add additional things?
So when you're applying for O1 and O3, by the way, for your children, with USCIS, they don't care about any of the parental consent stuff. It's usually at the consulates where they see, okay, divorced, do you have sole custody, right? And I have seen consulates challenge that and say, hey, if you're divorced and you have this kid, you want a visa, you bring them to the U.S., do you have custody? And they would want to see something, or else they're an accomplice, right? So take a look at the family law in London. Contact a solicitor. Hopefully they were able to help you get the right paperwork. And, and again, if the husband is completely missing or unknown, at least in the U.S., you could file a publication, right? Say, hey, I need custody of my kid. And if you have custody, then of course you could get a visa.
Submitted my 485 using the September 25, 2024 memo, which I believe is CSPA, due to attorney error in visa retrogression. Thoughts?
Oh, run me through the whole thing again?
Yeah, they submitted CSPA 485.
Okay.
Using, the September 2024 memo due to attorney error and visa retrogression. Thoughts?
Did they say September 2025 or 2024?
Sep 2025, 2024 memo.
Oh, okay. So last year's memo, I mean, I'm trying to understand. So you just recently filed the 45, but it was already past the new memo that canceled out all of CSPA, but
canceled out the new memos for
CSPA. That's right. So you recently filed, and your basis for filing this CSPA, even though it's way past the deadline by a month, you're saying there was an attorney error. And so is an attorney error something that is, an extreme situation that can basically pull back time so you can still qualify for CSPA? I want to say yes, because of the precedent, Madeline Lazetta. Attorney error is a very powerful tool to correct these small mistakes that have drastic consequences. So I would have probably recommended the same thing. So good luck and keep us posted.
So my marriage case for my green card was on the 1st of July. I haven't heard from them still. They told me 30 days, and it's been much longer than that.
I see. In that case, immigration is just slow. But just send an email, check up with them. Sometimes they need a little bit of push. We just did a premium processing case. It took like 3 months. It's supposed to be 2 weeks. We sent a case and immediately they were on it. So sometimes they forget. They're short staff as well.
So this is regarding the student who was abroad for 4 years and now wants to come back. They were only in the U.S. for 3 months before they went abroad. Is that bad?
Sounds bad to me, but come up with an explanation, right? You got the green card, you stayed here for a few months, and then the whole family just packed up their bags and left. Why? How? What did you guys do? What did the parents do? I remember it just did a case like this this year. We helped the parents come back last year, right, to save their green card first, right? Because again, the parents were gone for 4 or 5 years. So we helped the parents come back. And then after they came back, established roots, then they left. And then they came back with their kid. And we just did it with the kid to come back to the U.S. So now we're able to prove to the officer, like the intent was all here, but that the kid just had to continue to study. All these things are all good as well.
I had a governor pardon for a misdemeanor DUI. Is it safe to file for citizenship? This DUI was before the green card was granted.
Again, like I said, even without the pardon, we have seen plenty of DUI cases get approved for citizenship, right? Even 2 DUIs. So do your case well, you should still be able to get your citizenship. Even in this administration with the new memo on good moral character, do your best. I believe it's still possible.
Do you guys work with F1?
F1 as in international students, or F1 as in like immigrant petitions? I know it's super confusing. There's 2 F1s. So yeah. It depends on what you're asking, but the answer is both. Yeah, so it doesn't matter. But international students, we have a different department that does that. But yeah, it depends. There's so much services for F1, right? So we don't do everything.
When do you think I will get my green card? I only paid on Sunday before entering.
Oh, maybe 2 months at the most. Hopefully 1 month. They're actually getting faster.
Okay, so the son is a minor, right? And the parents did not abandon their residency. They had to leave because of their mom's cancer.
Right. That's a good story. So prove that, and then with everything else, and talk to the officer and show it's beyond your control and they didn't intend to abandon it.
So, okay, some follow-ups on the boarding school situation.
Yeah.
So the thing is, legally, we didn't abandon our residency, which I assume they mean they didn't sign the 407.
Right.
Although that, there is a distinction there. But we only want our kid to go back. We don't want to go back. Only the kid to go back. Also, go to the family friend as an emergency contact. Right. Can you guys support my kid once he's at the airport and talk for him?
Let's set up a consultation, right? And before you do, just go ahead and check out our YouTube channel. Check out the, dealing with CBP. And I think we have like over 60, 70 of these exact cases. And with regards to kids coming back, right, who've been out for a long time, I think we did at least 4 that I can remember. So take a look at that. And once you hear it, you see it, you know our process. If you feel like a consultation would help you, we gladly jump on a consultation, explain everything. There's so many different pricing structures, but I just want to do my best to help as many people as I can. So happy just do a consultation, walk you through the different options, and hopefully you could do it, right? But if you really want to retain us for the full service, again, we could talk about it, and then we could quote you a price then.
And a lot of info on the distinction between 407 form and abandoning your residency, all the requirements, all that stuff.
Right.
Can an 18-year-old go for a visa interview without a guardian?
Can an 18-year-old go to a visa interview without a guardian? I believe you can. I believe a lot of 14-year-olds, once they're above that, they go to the visa interviews on their own, if I remember correctly.
My dad missed his first master hearing by accident. What can he do?
Recalendar, contact the immigration lawyer, recalendar, say, hey, I'm sorry, and and then hopefully you get it real quick. At least he's not in detention, but you definitely don't want him to suddenly have a warrant out for his arrest, right?
Do affidavit letters need to be notarized?
Strictly, it's recommended. Have we seen a lot of cases get approved without it? Yes. But if you want to be safe, just do it. Every single one as well.
It adds that credibility to it, right?
Right.
Okay, everyone feel free to ask more questions. While we're waiting, I think one interesting topic is, and we talked to some lawyers about this last week too, is using how to responsibly and smartly use AI tools to evaluate your own case. So there's, it could go in a lot of different directions, but what would you say?
It's a great start, right? It's just like a Google search. Definitely, it's not the end all be all, but there's so much that most people don't know that if you have an AI, just treat the AI like a smart family friend that knows a lot, but is like, not a lawyer, but they know a lot. So you ask a question and they give you all these things, and you're like, oh, a lot of things to digest, but you wouldn't end your search there, right? You would do now a formal double check, right? So, and different AI chatbots have different answers, right? So don't just rely on one, do a couple, and ask it to challenge itself, right? But definitely, I think it's a great start to help everybody answer maybe 70, 80% of the question. And then definitely don't base your entire future on just what a chatbot says, right? So before you actually hit submit, before you actually mail out your package, and whether or not you could be approved or not, maybe sit down with another attorney, do a Zoom call and double check if everything is correct understanding, right?
What evidence do I need to remove conditions?
It depends on if you married to get a green card or you did an investment to get a green card, right? If you did an investment to get a green card, then you need to hire the 10 workers. If you got married to a green card if you got your green card through marriage to a U.S. citizen, then you need to prove that your marriage was bona fide and real. But if you got divorced already, then you have to prove that you either been abused or your marriage was real and it fell apart. All the instructions are actually pretty clear on USCIS website, but again, they write that set of instructions for every case category if that applies to all people, and it might not fit your particular situation. So if you look at the instructions and you know how to prove your case and you're fairly confident about it, you could totally do the case yourself. But if you feel like your case situation is so different from other people, then maybe it's good to jump on a consultation and we could discuss.
And what are some basic ways to prove the marriage is real?
Basic ways is what everybody will see and say, for sure, that is a real marriage. And the better way to think about that is reversing it. What would somebody not do when they're trying to fake a marriage, right? So again, marriage fraud is like over 90%. So you have to assume the officers will think your case is fraudulent. So you have to try to do things that is so real and something that fraudsters just are not willing to do. And if you can do that, then you're a little bit more confident. So let's think it through that example, right? What do you think going to a ceremony, taking a picture and having a certificate with a witness signature? Do you think fraudsters will do that or not do that? Probably do that because it's so easy, right? Having a joint bank account, $2,000, each of you put in $1,000. Now you have a document, a financial joint document. Is that easy or hard? You both have a Costco card. You both have a library card. You can mail it to the same address. Easy or hard? All easy. Should you do it? I mean, if it's real, is it good evidence? Sure. But what's something that's almost impossible? If I'm the officer and the two clients are sitting in front of me, let me see both of your phones. Let me see your Instagram discussions. Let me see your WeChat discussions, your Line discussions, your Kakao discussions. Let me see all the pictures you guys have together. What's his mom's phone number on your phone? What's your mom's phone number on his phone? And let's take a look at that, right? Are you telling me you never talk to the other person's mom? Right? What's your relationship with the other person's mom? Oh, it's all great. No arguments. Probably fake, right? So, there's a lot of things that the officers can take a look at and really be able to dissect if a relationship and marriage is real or not.
And common ones are like lease statement, utility, that kind of thing too.
Right.
I mean, yeah, I'm not saying anything. I just want to clarify for the audience.
Yeah.
Okay, how long does it normally take after filing a marriage case green card with lawful entry? I got married 2 months ago. When is it safe to file?
You have a lawful entry. So I'm assuming you came in as a tourist and then now you got married and now you want to file for the adjustment of status. I think one thing you really want to be aware of, right, is because legally you could file anytime. But the challenge is the officer might think, hey, did you defraud the U.S. government? Did you lie to the CBP officer at the airport? You said you were coming to Disneyland, but hey, you just got married right away. What's wrong with you, right? So you really want to prove that you had the original intent to come in as a tourist, but you changed your mind. And if you can answer that question well to your own satisfaction, then you can feel a little bit safer, right? That's, I think, the key difference. And we just did a success story on this a few weeks ago, where because they showed a return airline ticket and they didn't fly back and they stayed and got married, now the officer deemed them to have to need a waiver and to about to deny their case. And then, I mean, we helped them last minute and got everything approved with a waiver. But it's a huge headache if you have to deal with a waiver later on.
What does this mean under Form I-485? Quote, having been unlawfully present in the United States for more than 1 year in the aggregate on, or in the United States for more than 1 year in the aggregate, if you count all the days during all your stays that you were present in the United States after the expiration of period of stay.
What does that sentence mean?
Mm-hmm.
Okay. So in the aggregate, right? So let's say you came in as a tourist and you were supposed to stay for 6 months, but let's say you stayed for 8 months. Okay, now you have 2 months of overstay and then you leave. And let's say a couple years later, you somehow got an H-1B. You came in and then you stayed past your expiration date for H-1B. Your H-1B changed to H-4 and there was a mistake and somebody else filed it, but now your I-94 expired. So you stayed an extra 5 months and then you leave. And then let's say you were able to get another O-1 visa and you came in again, but somehow you overstayed again. So aggregate is adding all those dates together, the 2 months, the 5 months, the 7 months. And once it's over 1 year, sorry, you have a 10-year bar.
When you apply for a self-petition with a business, can you then get a green card and citizenship later?
So Yes, there are plenty of people who do self-petitions and get a green card. A lot of them start with a non-immigrant visa first, like an H-1B self-petition, E-2 petition, or O-1 petition. But in any case, you be able to work and live here in the U.S. first as a visa holder, and then you upgrade it to a green card, and then you upgrade it to a citizenship.
How do I buy my way into Albanian citizenship?
You should talk to an Albanian immigration lawyer. Today's story is about a green card holder who's left for almost 8 years and how they were able to come back. And it's not just this client. I think in the past 2 years, we've had several clients who are in this exact same situation where their passports were confiscated. Now, you might say, how does that possibly happen? Different countries around the world have different passport issuing laws, including the United States, where if you commit a certain crime or if you're accused of a certain crime, the Department of Homeland Security, the passport agency, they will not issue you a passport. And if you think the US is strict on that, other countries are far stricter. And you can imagine. And so this particular client, they were going through a civil proceeding, not a criminal one, just a civil one. But because of that jurisdiction, that judge issued a you cannot leave the country ban on this individual. So again, passport was confiscated. It was going through court trial. This client thought they were going to just be there for 2 years, 3 years. From all the consultations that he did with the different attorneys, the different teams fighting through this trial, they all said it would end soon. They would end soon. 2018, 2019, COVID, 3 years of nothing happening. After COVID, another 1 year, 2 years. Finally, case was resolved. He's innocent. Now he is able to leave. But now it's already been almost 8 years. How do you explain this to the U.S. Customs officer, right? And again, not just this case. There are several cases that have all been in this same situation. And what we did was we explained everything. But I think what's more important than explaining exactly what happened, which is very, very important, is the U.S. ties. So 8 years not in the U.S., the foreign government confiscated passport. They couldn't get out. The consulate would not issue a SB1. So they're really begging the customs officer to let them in. That's their only chance, their one shot. What is the officer supposed to do, right? They don't know foreign law. But to them, they could easily brush it off just saying like, oh, just talk to the consulate, right? We're not going to let them in, right? Just turn around and fly away, right? This is just too long. Or just explain this to the immigration judge. So what really wins these type of cases, if you're out for 4 years, 5 years, 8 years, your green card is, not your green card, your passport was confiscated, so you couldn't fly, is almost entirely dependent on your U.S. ties. So in this particular case that we just did this week, the mom is here, the wife is here, the son is here, and their children, U.S. citizen, and I think their spouse is a green card, but almost becoming a citizen, and they've been here the entire time, or most of the time. And so assets are here, retirement is here, family is here, everything is here, and they were a victim abroad. The previous case that we did, it was during the time, I don't know if you guys remember, it was the basketball player who went to Russia and got detained for a couple years. It was during that time. So I was able to use that story to talk to the officer. Hey, look, similar situation, also Russia, but instead of, being detained for that, they were detained for something else. And it just turns out they're a green card holder. So they didn't leave the U.S. with the intent of abandoning the U.S. residency, right? There's nothing clear of wanting to leave but cannot leave because of a court trial. Again, the officer was really understanding, was very nice after we explained everything. And more importantly, after fully proving that the wife, the parents, and the children are here, and that if they let them in and then we fight through this through immigration court, that they will likely win it on the merits. The officer says, okay, no problem, come in. We didn't even have to pay an I-193 waiver fine, right? That's another like $700. We didn't even have to pay for that, right? We were able to show it, explain, and we were able to get it. Now, obviously, it took like 6-7 months preparing for this case. I went down to Mexico. I talked to the officer. I explained everything. And then I went down again, and then we brought the client in. But to the officer, this case was approvable. So go ahead, proceed. And we were able to execute the plan accordingly. They contacted us before the trial was officially over, but it was getting close, and they know they were going to get a passport back. So we started arranging all the flights. So that was another thing that we showed, right? The moment they got the passport back, boom, they flew here. Your story matters. Your documents matter. Your circumstance matters, and how you present yourself matters. These are all extremely, extremely important. Yes, immigration law does say after leaving the U.S. for 1 year, this customs officer can inspect you and can confiscate your green card and give it to an immigration judge. Yes, they can force you to pay for a fine in order to let you in. You didn't apply for a reentry permit. You should have applied for a reentry permit. Under immigration laws, as a lawful permanent resident leaving the U.S. for over 180 days, you could get in trouble. You're supposed to be living here. But with all the wisdom of immigration law, it provides these exceptions, right? The officers have these discretionary authority to adjudicate whether or not somebody did, in fact, abandon their green card or not. And what we did was we just showed up the officer. The client did not abandon the green card. It was beyond their control, and all their housing and their investment and their life is here. And it was a mistaken act by a foreign entity. So please don't punish one of your own, right? And so, anyways, we've done so many of these cases now that's what I want to be able to share with everyone and explain. Because again, a lot of people recently have been just asking, like, what if my passport has been taken away? And it was this investigation, that investigation. The thing is, the customs officer could understand. Again, present your best, right? That's all you can do, right? Do your best, explain, and hopefully the customs officer understand and lets you in. That's what we did, and it worked, right? And this isn't the first case. We've done several of these already. So hopefully that helps. And that was the, again, out of the country, 8 years, passport confiscated, but we used that to the advantage of this case, and we're able to get back to it.
Okay, and we will end things there. Thank you, everyone, for watching. If you were, feel free to book a consultation on our website.
Thank you. Take care.